So as the synopsis outlines, what we're going to be talking about today is New York State's proposed 23 NYCRR 500, which is also known as the cybersecurity requirements for financial services companies. So we'll do a high-level review of why they're putting this in place, who it's affecting, what are the components of the covered entities that are required to comply with this regulation, and maybe some guidance for next steps. So without further ado, the background behind this, kind of why New York State is doing this is, as a lot of people know in the security field, is that a good cyber security program is essential to stave off cyber attack, provide the best service for your customers with respect to privacy and integrity of their data. But New York State has taken a first-in-nation stance with respect to actually introducing regulations for covered entities in New York State. So really they understand, the cyber landscape. We all see it on the news. Lots of companies are being attacked on a daily basis. So it's really bad, and New York State is really kind of getting ahead of this by proposing this regulation for financial services. Who is impacted? So the regulation basically states that banks, insurance companies, and other financial services institutions regulated by the Department of Financial Services are affected, if you will, by this regulation. There are some situations where companies are either too small, the revenue is not large enough, or they just don't have enough clients for the impact of cybersecurity to roll them into this regulation. And they also understand that the burden of instituting these cybersecurity programs on very small companies could likely drive them out of business. So they're not really kind of swept up in this regulation at this point, but I would imagine in future years they may have, a light version of this for smaller companies. So high level, the impact of the legislation is covered entities must establish and maintain a cybersecurity program designed to protect customers and ensure the safety and soundness of New York State's financial services industry. There are some very important dates that people should be aware of, actually coming up very soon. March 1, 2017, the proposed rule becomes effective. So this is moving rather quickly, and covered entities have 180 days from the effective date to comply with the requirements. However, they don't necessarily need to file or submit certification of compliance until February 15, 2018. So less than a year, people actually have to attest to their security posture. High level, these are the 16 compliance requirements, and it's a bit of an eye chart. And each one of these, can go into various levels of depth. But what we're going to do is just take a quick look at the high-level requirement for each one of these 16 requirements so that people can be a little bit more familiar with them. So number one, must have a cybersecurity program. This may seem obvious to people that have been working in cyber for a long time and have, somewhat mature cybersecurity programs, but, smaller companies that are in financial services or insurance companies, smaller insurance companies, if you will, may not necessarily have a very formal cybersecurity program. They may have something on paper or, kind of have wink and nod, and we have meetings about cybersecurity, but they're looking for very formal cybersecurity programs out of the covered entities. Requirement number two, you need to have a cybersecurity policy, which is all kind of part of the cyber GRC that is required to have a healthy and mature cybersecurity program. Risk assessments, this is kind of the meat and probably where a lot of covered entities will have to spend quite a bit of time, because a lot of the other requirements that we'll talk about following this one kind of drive off of the risk assessment. So, it requires each covered entity to conduct a periodic risk assessment, probably annually, and really, analyze the risks to your information systems, the non-public data that you guys house, and just your overall business operations to include physical security. It's got to be documented. It's got to be carried, and it's going to be carried out in accordance with, written policies and procedures. So kind of your entire GRC stack kind of needs to line up with your risk assessment. Let's see. Yep, you also have to do, analysis of the confidentiality, integrity, and availability of the information systems of non-public information. So again, this is more GRC type governance. And you also need to describe how the identified risks in your risk assessment will be mitigated or accepted, and how the cybersecurity program will address these risks. Well, you need to have a chief information security officer, so somebody kind of needs to drive this effort at your at the covered entity. I think what they're looking for is, this not getting kind of dumped onto IT as another responsibility that they need to take care of. Somebody needs to be designated at the company, and they need to be qualified in information security to lead this effort for the covered entity. They also do make a provision for companies that maybe don't have the manpower, the headcount, the expertise, that this position can be outsourced to qualified providers. They do make a provision in the requirements that penetration testing and vulnerability assessments do need to be conducted. So, requires each covered entity to include monitoring and testing developed in accordance with the risk assessment to basically support their cybersecurity program by performing penetration testing and vulnerability assessments. Audit trails. So they want to make sure that each covered entity includes audit trails designed to detect and respond to cybersecurity events. So this gets you into SIM type technologies to help you understand when, where, how you're being attacked, and be able to actually, provide evidence that you have remediated attack situations, or, how deep the attack may have gone. Number 7, covered entities are required to assess privileges. So, who has privileges in the covered entity to information systems that house non-public information. That should ultimately be limited to only the people that need to have access to it. So this provision or this requirement basically states that you need to review those access privileges. Number 8, so application security. So anybody who's developing their own in-house applications needs to have a documented application security program. So if you're developing systems that process non-public information, really the requirement is that you're building it securely. And if you're using third-party applications, there's also a provision under this requirement that says you need to vet these third-party applications. So you can't really just outsource the risk off to somebody else. They want you to be part of the due diligence to make sure that you're assessing the security posture of outsourced applications. Number 9, requirement number 9 is cybersecurity personnel. So you need to make sure that these people are qualified and you maintain the training of this personnel. Or if you do outsource it, you're outsourcing it to qualified third-party service providers. Okay, third-party service provider requirement number 10. So each covered entity needs to develop the policies and procedures designed to ensure the security of information systems and non-public information accessible to or held by third-party service providers is covered under the security policy. So the due diligence that you would normally perform on your internal systems, again, needs to be performed on the third-party systems and providers. Outside of just third-party development, this is cloud providers and what have you. Requirement number 11, multi-factor authentication. So essentially what the spirit of this particular requirement is that anybody who has remote access to the internal networks from an external network, the days of just using username and password are over, and probably should have been over for a long time, but they're they're mandating two-factor authentication. So something you have and something you know is typically how people explain the multi-factor authentication, you know, smart tokens and what have you. Item number 12, requirement number 12, that is, limitations on data retention. So just because you collect non-public information to process it for a period of time, really what this requirement is stating is that they don't want people stockpiling non-public information when they don't need all this non-public information. So let's say, you know, an insurance company has information on current policies, and then, you know, people come and go from those policies. They don't want the data from all policies to be collected indefinitely and create this stockpile of non-public information, such that when a breach may occur at a covered entity, the attackers aren't finding a treasure trove of information that's, say, 40 years old. Requirement 13 addresses training and monitoring. So you need to provide regular cybersecurity awareness training for all personnel. It doesn't matter whether they come into contact with non-public information or not. It's going to be top to bottom. And monitoring also makes the provision for implementing risk-based policies to monitor the activities of authorized users and detect unauthorized access of that non-public information. So of course, every company is going to have people that have access to this type of data, but they just want you to make sure that you're keeping an eye on the people that you trust. You know, it's trust but verify type situation. Requirement number 14. So this is where encryption comes into play for non-public information. And really what they're trying to do is promote the use of encryption to protect, you know, not only information that's at rest, but also the information that's transmitted. And oftentimes that's, you know, two different types of encryption technologies that need to come into play. Requirement number 15 is need to develop an incident response plan. So really what they're looking for covered entities to do is formalize how they will go about responding to incidents and, you know, and operate incident response in not a haphazard way, but a very methodical manner, such that you can get to the bottom of cybersecurity events in a very quick manner versus kind of putting your incident response plan together after the incident has occurred. So it's just preparedness. And number 16 is, this is where you need to communicate upward to the folks that are developing this regulations and requirements. So on an annual basis, you will need to submit evidence of compliance with these regulations by February 15th every year. And the first reporting period is coming up in February 15, 2018. So people do have some time, but as we all know, the calendar does tend to fly fast, and, you know, we all have other obligations and things that are not necessarily related to security, but, you know, driving the business forward. But these dates will be coming very quickly, as we all know. The other notification requirement is within 72 hours from the determination of the occurrence of a cybersecurity event, you need to notify the superintendent of the financial services. So as part of this regulation, the enforcement language is somewhat vague, which is interesting, but I just don't think they know how they want to go about enforcing this right now, but they certainly leave it very open-ended, which basically states this regulation will be enforced by the superintendent pursuant to and is not intended to limit the superintendent's authority under any applicable laws. So it could be as much as a slap on the wrist if there's a problem, or I would imagine financial penalties. I mean, I wouldn't envision somebody being, you know, losing their license to operate financial services in New York State. But I mean, if the violations were so egregious, I suppose it could get very burdensome for people that are not pursuing compliance. things could change with this legislation. They just closed out a public comments period. That just ended on January 27 this year. So I would imagine some of the feedback that they got with respect to this, these regulations could be massaged, modified, pulled back, expanded. So I think we'll see over the next couple of months, or certainly over this year, how the regulations may change. I don't think they'll change drastically, but they may just be tuned up a little bit from this feedback. So kind of closing things out, there's definitely a lot of work to be done. You know, whether your cybersecurity program is mature, you know, you're going to have some paperwork that you need to collect, provide evidence that you're in compliance with these new regulations, and certainly provide evidence of that. If you're in a less mature security position, then over the next 11 months, you likely have a lot of work to do to get close to compliance. So again, we're 11 months from the first reporting period, so you know, those companies may be looking for a lot of outsourced help to probably get them in a position where they're in compliance. And that is kind of our high-level analysis of this regulation. Again, we expect to see some change in these regulations. We don't necessarily expect to see wholesale changes, but I would imagine to see a little bit of tune-up with some of this legislation and regulations. With that, if you have any questions.
Jim, we do have one question here.
Shoot.
How will this rule apply to smaller companies that provide credit services, such as independent car dealers or appliance stores that offer loans and financing for their customers? Are they in scope for this law?
I believe they would come under the processing, housing, transmitting non-public data. So they would likely, my guess is they would likely get wrapped up in this particular regulation, because it is finance information and certainly non-public type data that they're handling. But again, this is, you know, certainly questions that each company that feels as though they're affected needs to, you know, maybe work with their legal counsel and, you know, get advice. But certainly if they're regulated by New York State Department of Financial Services, then they are likely affected, depending on their size, because there are some ways to avoid this regulation in the first round, and I believe some of that is, you know, you need to have less than 10 employees, your revenue has to be less than $5 million, and you have less than 100 clients, for example. So there are some outs, but at a high level, I would think that they would probably want to examine their options, but they're likely targeted by this regulation.
And we have some more questions coming in now. Another here is, what is the major implication for non-compliance in terms of penalty?
Well, that's where it's rather vague, where they leave basically their one comment about, let me go back to this, enforcement. So basically they leave it up to the superintendent to dole out, you know, handle enforcement. You know, I would imagine, you know, it's probably financial related, you know, it's been in non-compliance. And if it's habitual, I would imagine, you know, year after year, you know, financial services companies, a particular financial service company that is not in compliance or showing that they're on path to compliance is probably going to get harsher penalties over time. If in fact it's financial penalties, because as you can see here, they leave it rather vague.
Okay, we have another question here as well. If we want to get additional information on guidance for the items covered in this regulation, do you have any recommendations?
Yeah, I would go to the New York State Department of Financial Services website. and they have basically all the details with respect to the regulations, and they do have some summary version of this particular information. But outside of that, if you're looking to really determine whether you're impacted by this regulation, you probably want to seek some legal counsel, maybe your CPA, that have some information with respect to where your company stands with respect to being affected by this regulation.
Okay, I like this next question actually. Can you expand on which organization is a covered entity? Are those based in New York alone?
As far as I understand, anybody who is doing business in New York, so if you are a regulated entity, if you're regulated by the New York State Department of Financial Services in any way, even if you're headquartered in Omaha, Nebraska, if you have an entity that operates in New York that is covered by NYCRR, you're in scope at least for that operation that operates in New York State.
Awesome. And another question here. The regulation was supposed to take effect after December 2017, and it was moved to March 1st. Do you see the regulation moving to law?
That's a good question. That I don't have, but they seem to be vigorously pursuing this regulation, and they put a little bit of time into it. So I think it depends on the amount of pushback they get by the covered entity lobbyists, perhaps, to put it mildly. I could see it being the dates maybe moving a little bit, but I think the spirit of this will, my guess, only a hunch, the spirit of this will live on in some form. But when, the date is still March 1, but that they could obviously move, or they may offer transition periods and larger windows for folks to come into compliance. Give them 1, 2, 3 years.
Okay. Doesn't look like we have any other questions coming in right now. I'm going to pass this back over to Kevin to do our closing statements here. Thank you, Jim.
All right, that was great. Thank you so much. Got done a little bit early, going for speed. That's fine. It's Friday, right? So just to review, we've got a lot of conferences coming up this year, both online and in person. If you want to know anything about these presentations, past or upcoming, please reach out to iSECURE. We have a presence on the web, telephone. You can email us at events@isecurenet.net. That was events@isecurenet.net. We can also provide proof of attendance for CPE credits. Please let us know. We'll be sending out certificates next week. Finally, we'll be